discussion. I want to make sure people understand.
I'm sorry, I still don't, it's not clear to me. I think this really has potential for great confusion. Why, if it's somehow treated differently if it's in Rule 103, that currently they report things that are not accessible to the public. But if it shows up in 103, it now is treated differently?
I mean, currently, all payment information we receive is in an investigative nature. We have one system now, and that's an investigative system, and we collect all this payment information in accordance with that. It's all confidential, unless the board takes public action. Now we're setting up a new system where physicians are going to be reporting to us under a separate system for the purpose of publishing this to the public. Now, there's a difference between publishing, which would be basically our website, and making something available to the public. That's the language of the statute, making it available to the public. So, and the statute says that anytime we receive something from a physician or a physician assistant pursuant to this profile system, we have to make that available to the public. The board decides how much of that it wants to publish. So if we receive payment information from a physician or physician assistant pursuant to this profile system, then we've got, at a minimum, we've got to make it public, available to the public, whether we publish it or not. So 103 talks about what we're going to receive. Anything we receive under 103 has got to be made available to the public. Under 105, we talk about what we're going to publish. But if you have a $20,000 payment and you're requiring under 103 for the physician to report that to the board, then it won't be published on our website pursuant to Rule 105. But it is here in our office and available to the public if someone should call and ask for it.
I hate to belabor this, but I think it's an important point. Could we consider removing Rule 103 altogether? Because the licensees still have to report it to us. We'll have the information and we'll be able to publish what the rules say we should publish. We'll still be able to go through our process of investigations. Rule 103 really doesn't add anything other than access to the public of information that we do not intend to publish.
I guess I'm
Does
just
that make
confused.
sense?
I'm just confused because it seems like it almost makes everything ludicrous. If they're gonna, if 103 makes all this information available to the public, then it doesn't matter what we publish, because then anybody can call up anytime they want and say, I want all this information regardless of judgment, payment, settlement, amounts, standard of care, whatever. 103 puts all this information out there to the public.
Mr. Mansfield.
To address part of Dr. McCullough's point, you have to have Rule 103. Part of the requirement created by the legislature is that you make rules telling physicians what it is they have to report to you in connection with that part of the statute. So you do need rules specifying to the physicians and physician assistants what it is they have to report. And then backing up a little bit and looking at it from a little broader perspective, going back to Dr. Walker's original question, from a practical standpoint, how to work, I think, how it could work, is for investigative purposes, we'll continue to get all payments reported to us pursuant to North Carolina General Statute 90-14.13. Now, those are reports from the insurance companies, from self-insureds, and from physicians who pay out of their own pocket in cases affecting or involving them. You know, as you know, we also query the NPDB every year and get a one report of all the payments that have been reported to them, which will tend to maybe catch some that were missed or otherwise. And then, and where it gets tricky, but we can do it, I think it's a practical matter that it can be made clear on the annual registration form. I think you'll continue to ask questions that you're already asking currently on the annual registration form, and you may have to add some language to clarify, and also perhaps pointed out in an article like Dr. Saunders said, you know, there'll be a section where you, the licensee, provide information that's essentially investigative in nature. And then there's going to be, I would think, a sort of discrete section that says, please provide the following information pursuant to 90-5.2. So as you all do your annual registration, you'll see this, and I think it'll make sense to you and the rest of the physicians and PAs, because you'll collect information, different sections for different purposes. And to get back to this sort of point that David was talking about, from my perspective, looking at it as a lawyer, I think it's probably important to change Rule 103 as has been moved, because the way we read the statute 90-5.2 is that once we receive it, pursuant to 90-5.2, it's going to be public information. And you previously made a motion to exclude affirmatively publishing payments greater than $25,000. I think if that's your intent, to be consistent with that intent, you probably want to go ahead and change Rule 103. Otherwise, you've effectively erased the threshold that you put in place in Rule 105.
Yeah, I'm thinking that less than 25, you said
Yeah,
greater than
yeah.
25,000. you meant less.
Yeah, yes, ma'am.
And we actually already are doing that on our renewal form. We have actually started building sort of a separate section in the renewal form to ask specifically profile-related information. So I think that we will be able to separate out both our investigative function on the renewal form and the profile gathering information on the renewal form. So hopefully it'll be clear to people what we're